step back in time with us to the vibrant industrial Australia of the mid-1960s. Railways, absolutely central. The lifeblood, really, connecting cities, moving goods. I mean, critical national infrastructure.
Couldn't function without them back then.
Exactly.
Yeah.
And protecting the tech, the sort of cutting-edge stuff that kept those trains running, well, that was patents, these legal shields for innovation.
But patents can also spark some pretty fierce battles.
And that's where we're going today. What happens when a big international company holding one of those patent shields clashes head-on with the state's need to, well, keep its trains actually moving?
And maybe more interestingly, what if that whole clash gets decided super fast, not by some long, drawn-out trial, but by a single, swift legal move?
You've nailed it. That's the core tension. We're diving into a really high-stakes legal drama today. It's all centered around a vital bit of railway tech.
And this international patent holder, General Steel Industries, Inc., taking on the New South Wales Commissioner for Railways right in the High Court.
Yeah. It's a fascinating story where this fight over using an invention, it sort of morphs into a battle about government power, statutory interpretation, and courtroom strategy. So our mission here, using the sources you've provided, is to trace the procedural journey, the drama, really, of General Steel Industries, Inc. versus the Commissioner for Railways, NSW. It's a 1964 case.
A classic.
We want to unpack the key players, you know, the companies, the judge, the heavyweight legal teams involved, and see how one specific bit of the Patents Act basically delivered a knockout blow before the main event even got going.
So we're looking at what happened before, during, and just after that crucial hearing, using only the material we have here.
Exactly, focusing on that procedural story.
It's a brilliant case study, actually. It shows how knowing these specific legislative carve-outs, these sort of niche rules, can be just as vital as understanding the main area of law, like patents.
Especially when you're up against the government.
Definitely. The usual rules of engagement, they can get totally rewritten.
Okay, let's set the stage for this legal showdown.
Right. So, at the heart of it all was the plaintiff's invention, General Steel Industries, Inc. They held the Australian patent for something called a railway vehicle body and truck central bearing.
Sounds important.
Oh, very. The sources describe it as sophisticated, absolutely critical, think stability, safety, giving passengers that smooth ride. It wasn't some minor widget.
So defending this patent for General Steel, an international company, probably U.S.-based given the Inc., this was clearly a big deal.
Absolutely worth fighting for, even in a foreign court like Australia's High Court.
And they didn't mess around. They launched their action right at the top in the High Court, and their first move, seeking injunctions.
Yep, those court orders to basically stop the alleged infringement cold. Yeah. Stop anyone using their patented design.
And who are they targeting?
Well, they named 3 defendants, all involved in putting these railway carriages together for the state. First, the big one, the Commissioner for Railways for New South Wales.
Okay. What was the accusation against him?
General Steel claimed the commissioner was contracting to have manufactured structures that copied their invention. They saw him as the one pulling the strings, the orchestrator.
Got it. And the others?
Then you had the companies doing the actual physical work, AE Goodwin Ltd. They were accused of making and manufacturing the infringing parts, sort of the industrial scale production.
Makes sense.
And the third was Tulloch Ltd. Their alleged role was assembling these infringing structures into the final complete railway carriages.
So the picture General Steel painted was, the commissioner orders it, Goodwin builds it, Tulloch puts it together.
Precisely. And crucially, the plaintiff connected them all directly. They claimed that Goodwin's and Tulloch's actions were done pursuant to agreements with the commissioner, specifically to make these carriages for his use.
And there was a really key detail in that allegation, wasn't there?
Yes, this is vital. General Steel didn't just say, maybe the contractors infringed accidentally while doing the job. They alleged the agreements themselves, the contracts between the commissioner and the others, actually call for and require the use of the plaintiff's invention.
Wow, so they were saying the infringement wasn't a mistake, it was baked into the specs, demanded by the state authority itself.
And that's exactly how they framed it, which really ups the stakes.
Given those stakes, and the parties involved the State Railway Authority, international corporation, you'd expect some serious legal firepower.
And you'd be right. For the plaintiff, General Steel, the solicitors were Minter, Simpson & Co., a well-known firm. Their counsel were N.H. Bowen QC and C.J. Bannon. QC, Queen's Counsel, top-tier barristers.
Right, and on the defense side, For the commissioner.
Representing the Commissioner for Railways, NSW, the solicitor was R.J. McKay. He was the Crown Solicitor for New South Wales, the state's top lawyer, essentially. And counsel were R.J.A. Frankie QC and R.J. Ellicott. More heavy hitters.
Okay, what about the contractors, Goodwin and Tulloch?
For A.E. Goodwin Ltd., the solicitors were Murphy and Maloney. Their counsel were W.P. Dean and P.R. Capelin.
Hang on, W.P. Dean, that name rings a bell.
It should. That's William Dean. He'd later go on to become a justice of this very high court he was arguing in, and then, of course, Governor General of Australia. So a future legal giant involved even then.
Incredible. And for Tulloch LPD.
Solicitors were Allen and Hemsley, another very established top-tier firm, and their counsel were J.D. Holmes QC and A.H.S. Conlon.
So a really formidable lineup on all sides. Looks like everyone was settling in for a long, complex patent fight.
You'd think so. But that's not what happened. The defendants didn't just file defenses and wait for trial. They went on the offensive with a pretty bold procedural move.
What did they do?
A real gambit. All three defendants filed separate summonses. These are formal applications to the court before even filing their main defenses. And their goal was audacious. To get the entire case thrown out summarily.
Thrown out. Before it even really started. On what grounds?
Their core argument was that General Steele's claim was, well, fundamentally flawed. That they had no reasonable cause of action, or perhaps no cause of action at all, that could possibly succeed in law.
Okay, so wait. They weren't arguing yet about whether the invention was copied or if the patent was valid?
Not at this stage, no. They were making a much more fundamental legal argument. That General Steele was legally barred from even bringing this specific infringement lawsuit against them. Full stop.
How could they argue that? What tools did they use?
They use a couple of things. First, the court's own inherent power, its built-in authority, to stop cases that are an abuse of its process. You know, cases seen as frivolous or utterly without merit.
Okay.
And they pointed to specific high court rules. Order 26, Rule 18, that's one about striking out pleadings, like the plaintiff's statement of claim. And Order 63, Rule 2, which deals more broadly with summary disposal of actions.
But the main weapon, the core of their argument, wasn't just court rules, was it? It came from legislation.
Absolutely. That was the killer argument. Their applications were built squarely on Part 14th of the Commonwealth Patents Act, 1952-1960.
And what does that part do?
It deals with a very specific situation. The use of patented inventions for the services of the Commonwealth or state. Basically government use.
Okay. And Section 125(1) sounds like the key bit here.
It really is. It basically says that the Commonwealth government, or a state government, or importantly, a person authorized in writing by them, can make, use, exercise, or vend a patented invention.
If it's for?
If it's for the services of the Commonwealth or state. And Section 132 helps by clarifying that state also includes an authority of the state.
Right. I think I see the argument forming. The commissioner says, I'm an authority of the state.
Check.
The railway system is a service of the state. Therefore, my actions contracting for these parts are covered by Section 125.
Exactly. That's the commissioner's core defense. And then comes the knockout punch. Section 125, subsection 8.
What does that say?
It's brutally clear. It says, no action for infringement lies in respect of the making, use, exercise, or vending of a patented invention under subs.
Wow. So if the defendants could convince the court their actions fit under 125(1), General Steele's infringement lawsuit is just locked, statutorily barred.
Completely. The act itself says you cannot sue for infringement in that situation.
The sources mentioned something interesting about the contractors too, Goodwin and Tulloch, something about authorizations they got after the lawsuit started.
Yes, that's right. They apparently produced written authorizations from the commissioner, dated July 16, 1964. These explicitly authorized them under S-125 to make and assemble the parts for him.
That date, July 16, was after General Steele filed suit, wasn't it?
It was, which does suggest maybe they were obtained reactively, to shore up the defense once a legal battle was underway. But as it turned out, the judge found a more fundamental reason why the contractors were covered anyway.
We'll get to that. But just to keep our procedural story straight, the legal teams arguing these crucial dismissal applications were the same ones we identified earlier.
Yes, exactly the same lineup. For the commissioner, Crown Solicitor R.J. McKay, instructing R.J.A. Frankie QC and R.J. Ellicott. For Goodwin, Murphy and Maloney, instructing W.P. Dean and P.R. Capelin. And for Tulloch, Allen and Hemsley, instructing J.D. Holmes QC and A.H.S. Conlon. All squaring off again.
Okay, so these applications, these summonses for summary dismissal, they bring the case before a single judge of the High Court for a hearing that turns out to be absolutely pivotal.
And that judge was the Chief Justice himself, the Honorable Sir Garfield Barwick.
A towering figure in Australian law.
Absolutely. So he's sitting alone, tasked with deciding whether this major international patent case gets shut down right at the start. The hearing itself actually happened over 2 days, July 23rd and August 6th, 1964.
You can imagine the pressure in the courtroom. What was the argument from General Steele's side? Their lawyers were N.H. Bowen QC and C.J. Bannon, instructed by Minter, Simpson & Co.
They argued passionately against dismissal. Their whole point was, look, this power to just throw out a case summarily, it should be used incredibly rarely. Sparingly employed was the phrase.
Only for cases that are completely hopeless.
Exactly. Cases so obviously untenable that it cannot possibly succeed. They basically pleaded for their client's right to a proper trial. They said, look, let the defendants raise these legal points later, in the normal way.
Like through a demurrer or arguing points of law before trial.
Precisely. Demurrer, points of law, a special case dated for the court, the usual procedural tools. They were fighting for their day before the customary tribunal, meaning a full trial, with evidence, cross-examination, the whole works.
You can really feel them fighting for that fundamental right to have their case heard properly. How did Chief Justice Barwick respond to that? He must have known the bar for summary dismissal is high.
Oh, he absolutely acknowledged it. The sources show he went through the case law carefully. He cited all the different ways judges had described the test. Manifestly groundless. Under no possibility can there be a good cause of action, something that would only lead to useless expense.
He quoted Justice Dixon, too, didn't he? Another High Court legend.
He did, quoting Dixon J., saying, "A case must be very clear indeed to justify throwing it out early." Barwick emphasized the need for great care so you don't wrongly deny a plaintiff their chance at trial if there's a genuine real question to be debated.
But there sounds like a but coming.
Well, yes. Barwick CJ also made a crucial point. Just because deciding the issue required argument, perhaps even of an extensive kind, that didn't automatically save the case from dismissal. If, after hearing all that argument, the claim was still shown to be so clearly untenable that it cannot possibly succeed.
So he was saying, I'll listen carefully, we can argue this out fully right now, but if your case is fundamentally doomed in law, I will act.
That's the message. He was prepared to make the tough call if the law, as he saw it, demanded it, even at this early stage.
And the defendants counsel Frankie and Ellicott for the commissioner, Dean and Caplan for Goodwin, Holmes and Conlon for Tulloch. They must have seized that chance.
They certainly did. They built their arguments on that statutory fortress, the Patents Act.
So Frankie and Ellicott for the commissioner, their argument was straightforward. Sections 125 and 132.
Pretty much. Commissioner, authority of the state. Railways, service of the state. Therefore, his actions in getting the parts made were covered by S-125, which means S-125-8 blocks the infringement suit against him. Simple, direct.
And how did Barwick analyze that specific point? Did he agree that the commissioner was an authority of the state? That seems key.
It was absolutely central, and Barwick CJ didn't just wave it through. He did a detailed dive. He looked at the laws that set up the Commissioner of the Transport Act, the Government Railways Act. He looked at his status, basically representing the Crown, his control over railway property, the money, the fact he managed a government department under a minister.
So really digging into the structure and function.
Yes. He weighed all that up, including the historical connection between railways and government functions. And his conclusion: the railway system was undoubtedly a service of the state, and the commissioner was indeed an authority of the state for the purposes of the Patents Act.
And was that conclusion clear enough for summary dismissal?
In Barwick's view, yes. He found it was sufficiently clear, sufficiently definite to meet that high standard. So the path was clear to dismiss the case against the commissioner based on 25R8.
Okay, that deals with the commissioner. What about the contractors, Goodwin and Tulloch, their lawyers, Dean, Caplan, Holmes, Conlon? What was their angle under Section 125?
Their argument hinged on being authorized in writing by the commissioner, who Barwick had just found was an authority of the state. If they were authorized in writing, their actions, making and assembling, were also covered by S-125-1, and the suit against them was also barred by S-125-8.
And authorized in writing was the crucial phrase there. How do they establish that, especially if those formal post-lawsuit authorizations weren't the main focus?
This is where it gets really interesting. Barwick CJ looked back at the plaintiff's own claim document, the statement of claim. Remember how it said the agreements between the commissioner and the contractors call for and require the use of the plaintiff's invention?
Yes, that the contracts themselves specified the design.
Right. Barwick interpreted that allegation to mean the agreement stipulated the use of this specific, allegedly infringing design. Now, the big question for him was, could he be certain, to the high degree needed for summary dismissal, that these agreements were in writing?
Because the plaintiff's document didn't explicitly say written agreements.
Exactly. That could have been a stumbling block. Barwick acknowledged it gave him pause. But he reasoned in two steps. First, just common sense. For huge, complex manufacturing deals like making railway carriages, it was highly unlikely they'd just be based on a verbal agreement.
Okay, probability. But that's not certainty.
True. But then came the clincher. He looked outside the Patents Act to a New South Wales state law, Section 22 of the Government Railways Act, 1912.
And what did that say?
It required the railway commissioners, the predecessors to the current commissioner, to make contracts in writing for certain types of work they were authorized to do, including, importantly, the manufacture of things like railway carriages.
Ah, so a state law mandated written contracts for this exact type of work.
Precisely. That state law requirement, combined with the nature of the work, gave Barwick CJ the certainty he needed. He concluded that these agreements, the ones stipulating the invention's use, must have been in writing.
And therefore?
Therefore, those agreements themselves constituted the necessary authority in writing from a state authority, the commissioner, under the Commonwealth Patents Act, Section 125, for Goodwin and Tulloch to make and assemble the parts.
Amazing. So their actions were also covered by SES 125.1, and the infringement suit against them was also barred by S 125.
That was his conclusion. And he specifically noted he reached this finding without even needing to rely on those potentially reactive, post-lawsuit written authorizations they'd also submitted. The original agreements were enough.
So the statutory defense held up for all three defendants. During the arguments, was there any discussion about maybe converting the claim? Like, instead of infringement, maybe General Steel could claim compensation under the Act?
The possibility was raised. Section 125, subsection 5 does provide for compensation in these situations. But Barwick CJ, according to the sources, found that particular path was not open at this stage in the context of this hearing about dismissing the infringement claim.
So no lifeline offered during the hearing itself. It was all or nothing on the infringement suit.
Seems so. The battle lines were drawn squarely on whether that infringement action, as pleaded, could survive the S-125 statutory bar. And again, the same legal teams argued these points right through.
Right. So the arguments concluded, and then Judgment Day. How quickly did that follow?
Pretty swiftly. Chief Justice Barwick delivered his judgment on November 9th, 1964.
And the verdict. Let's start with the commissioner.
For the commissioner, Barwick CJ stated he was fully convinced. The commissioner's actions contracting for the parts for the state railway service squarely fell within sections 125 and 132 of the Patents Act. Meaning the infringement action against him was absolutely precluded by S-1258. Barwick found the claim against the commissioner was clearly untenable and simply could not proceed.
Okay. And for the contractors, Goodwin and Tulloch?
Same result, essentially. Having found that the agreements requiring the use of the invention were, by necessity, in writing, he concluded they were authorized in writing by a state authority. So their actions in making and assembling were also covered by Section 125.
And the claim against them was?
Manifestly groundless, in Barwick's words, also blocked by S-125.
So the statutory shield worked perfectly for all three. What did that mean for General Steel's actual lawsuit document, the statement of claim?
This is where the hammer really fell. Barwick CJ used his power under that High Court rule, Order 26, Rule 18. He didn't just say the claim was weak. He ordered the entire plaintiff's statement of claim be struck out. Gone.
Not even a chance to amend it to try and fix it?
No. He was very clear on that. He said this wasn't a case where just tweaking the wording could help. The defect, the S-125A statutory bar, was fundamental to the claim as it had been brought. It could be salvaged.
So, striking out the claim, what was the final order for the whole case?
Having struck out the claim and concluding the whole action was manifestly groundless and pursuing it further would just be useless expense, he took the final step. He dismissed the entire action against all three defendants.
Wow. So General Steel's big push for an injunction, their whole infringement case in the High Court, just stopped dead in its tracks at this preliminary stage.
Completely shut down before it ever got to a full trial on the patent merits.
And the costs. Who paid for all this legal argument?
As usually happens when a case is dismissed, costs followed the event. The plaintiff, General Steel Industries, Inc., was ordered to pay the defendant's costs.
A costly exercise in the end for them. And again, the same legal teams, Minter Simpson, Bowen, Bannon for General Steel, McKay, Frankie, Ellicott for the commissioner, Murphy, Maloney, Dean, Capelin for Goodwin, Allen Hemsley, Holmes, Conlon for Tulloch were recorded right through to the end of this judgment phase.
That's right.
So the infringement case was over, dismissed. But you mentioned Barwick. CJ kind of pointed towards another possible path for General Steel.
He did, right at the end of his judgment. It's a crucial remark. He said, and I'm paraphrasing slightly, the plaintiff's remedy, if any, for the acts it complains of is for compensation under Section 125, subsection 5 fit.
Ah, that compensation section again. So he slams the door on infringement, but points towards 125. What exactly does that subsection do?
It basically outlines the alternative route when the government uses your patent under S-125. Since you can't sue for infringement to stop them using it, S-125 gives the patentee a right to compensation for that use.
So how is the compensation decided?
Well, ideally, the terms for the use, including payment, are agreed between the patent holder and the government authority. But if they can't agree, then the terms are fixed by the High Court itself.
That fundamentally changes the dynamic, doesn't it? Instead of the patent holder having the power to say, stop using my invention, the power shifts.
Completely. The state gets to use the invention for its services, and the patent holder's right transforms from one of prohibition, injunction, to one of remuneration, getting paid, potentially.
What's the legacy of this General Steel decision, then, for patent holders dealing with government?
It's pretty significant. It clearly shows that your patent rights, your exclusive rights, aren't absolute when the state needs to use your invention for its services under S-125. You might face this use now, pay later scenario.
If they decide compensation is due, of course.
If compensation is determined to be payable, yes. Your power to block use is overridden, and you're potentially left arguing about the price tag after the fact.
Did the case have broader implications beyond just this patent context?
Yes, a couple of things. Barwick CJ's detailed analysis of why the commissioner counted as an authority of the state became quite influential. That methodical look at the statutory basis, the links to the crown, government control, finances that set a sort of template for how you assess if other statutory bodies meet that definition.
And what about the whole summary dismissal aspect?
Well, the case did two things there. It definitely reaffirmed that, yeah, the bar for throwing out a case early is very high. Courts are rightly cautious. But it also powerfully demonstrated that courts will use that power decisively if, after hearing proper legal argument, a claim is shown to be truly manifestly groundless, even against a major international company with top lawyers. It showed the procedure isn't just theoretical.
And maybe the biggest lesson is about the power of knowing the statute book inside out.
Undeniably, look at the defendant's strategy here. They use these specific clauses in the Patents Act, cleverly linking them even to a separate state law about written contracts to completely sidestep a potentially long, expensive fight about the patent itself.
They won on procedure and statutory interpretation, not on the technical merits.
Exactly. A masterclass in leveraging legislative defenses, especially when the government is involved.
Now, there's one loose end. Barwick pointed General Steel towards compensation under S-125. Do our sources tell us if they ever actually went down that road? Did they pursue a compensation claim?
No, the sources we're working from don't cover that. They detail the dismissal of the infringement action and Barwick's final comment, but whether General Steel subsequently launched a separate action for compensation under S-125, that outcome remains unknown based on this material.
Okay, so recapping this deep dive, the General Steel case is just a fantastic illustration of how specific laws like these services of the state rules tucked away in patent legislation can fundamentally change the legal landscape.
Yeah, it turned what looked like a standard, albeit high-stakes, patent infringement fight into a case that was over before it really began, all thanks to a successful statutory defense strategy.
It's a stark reminder, isn't it, that understanding these legislative details, these potential shields and carve-outs, and knowing the procedural playbook is just as crucial as knowing the main area of law, particularly when you're dealing with government bodies.
Absolutely critical. The architecture of the statute itself can be the entire ballgame.
It really leaves you thinking, though. Barwick CJ, Essential tells General Steel, can't stop them using it, maybe you can get paid later. When the state has that power use first, argue price later, what does that really do to the value of a patent? Does it truly strike a fair balance between the public need for services and the inventor's right to control and profit from their creation? Is compensation after the fact really the same as having the exclusive right in the first place?
That's the million-dollar question, isn't it? Does that after-the-fact compensation, potentially determined by a court, truly reflect the value of the innovation and the exclusive right that was overridden? It's a debate that continues.
Definitely food for thought. Well, that was a fascinating deep dive into General Steel Industries Inky Commissioner for Railways, NSW,